Hey there, YouTube fans. Mike Palumbo. I got a great legal lesson to bring you over the Bruce Springsteen DWI arrest and summary discharge of the charges. And I really wish I had done this video sooner, before it was made public that he was that the charges against Bruce Springsteen were dismissed, because that was my prediction. But I can't really prove that I'm a savant now because I'm doing the video after it's already become public that the charges were dismissed. But there's so much to learn about the law of DWI and the federalism and federal court, state court, and New Jersey DWI law. That it's and what it means to be what the legal limit is. That it's just a great case to do a case study on. So, for those of you who don't know, I think back in November, Bruce Springsteen was arrested for DWI in the Sandy Hook Federal State Park. Apparently he was riding his motorcycle around, and some fans spotted him, and he was gracious enough to stop and take pictures, and was pressing the flesh with the fans. And all my information, by the way, comes from like the newspaper, like what's in the news, what I read on Yahoo News and whatnot, and radio reports. But what happened was someone had a little bit of tequila, and he took a shot of tequila, and somehow a cop observed him doing this. At least that's the report. And from what I understand, the cop told him not to drive, and he drove anyhow. Now listen, I'm not a big Bruce Springsteen music fan. I don't dislike him at all, but he doesn't seem like a contemptuous person to me. He just doesn't seem like the kind of guy that's going to thumb his nose at the cops or go out of his way to give the police a hard time. So I don't really know, how true that that is, that some cop actually saw him and warned him not to drive first. I also heard that he was sitting on his motorcycle, with the keys in the ignition, which is operation. He wasn't driving it. The cops saw him and arrested him. Then he was arrested for DWI, and then he blew a .02, which everyone's saying, well, that's the legal limit. It's beneath the legal limit. That's not true, okay? It's not true. There's no such thing as a legal limit. This needs to be clarified, because the public, the public has it wrong, and the public has it wrong because of the way it's been advertised over the years. But he was arrested for DWI with blue .02, and then he was brought to federal court, which is another interesting overlay. Why federal court? Because he was on federal property. He was arrested by a federal parks police officer. So he wasn't in the state system. He was in the federal system. And then it got dismissed. And I knew I felt strongly, let's put it that way, that was going to get dismissed because of the facts that, as I stated them, although they're not really from reliable sources, no one was saying anything else. Those were the only facts out there. And even though there's no such thing as a legal limit, it was a .02. And, if he just did like a small, amount of alcohol before he got back on his bike, he clearly wasn't intoxicated, even though he blew a .02. And we're going to go into that. Okay, so the first thing is operation. You don't need to physically be driving a vehicle for DWI purposes to have operation. So operation for DWI purposes in New York and New Jersey. I'm a New York lawyer, but I know a bit about New Jersey laws. Key in the ignition, you behind the wheel. The car does not have to be moving. It has to be on a public roadway. And in New York, and I don't know about New Jersey, but in New York, a public roadway is very expansive. For DWI purposes, a public roadway could be a strip mall. So it's private, but it's considered a public roadway. So with a motorcyclist, if he's sitting on his bike, it's turned off. Even if it's turned off, keys in the ignition, he's operating it. So that, I call it a technical operation. I've had a lot of clients in DWIs over the years been sleeping off in their car, and their car is on, sometimes it's not on, but the keys in the ignition, a cop happens upon them, they're drunk, and they have technical operations, so they arrest them. And those cases generally get dismissed. So, but they did have operation. Now, the whole thing about the legal limit, .02, well, he blew the legal limit, so they should let him go. Here's how it is, okay? Before there were breathalyzers, the police arrested you, and they still do arrest you under observation only. So they observe you. They pull you over. You were speeding. You were swerving. Whatever. They smell the alcohol. They do the field sobriety tests, and based on the totality of their observations, they have probable cause to believe you're intoxicated. They arrest you. So you're not taking a chemical test yet. You're already under arrest. We call it common law DWI. That's one way. That is one count of DWI. In New York and New Jersey, and every other state that I'm familiar with the law, before you take a chemical test, you're already under arrest for DWI. So the point of the chemical test is twofold. One, to continue to build probable cause for the common law arrest, but more importantly, it's another count or another way of being found guilty of DWI. DWI means driving while intoxicated, and what they have to prove is that your ability to drive a car was impaired because you were intoxicated. And impairment means an inability to properly operate your vehicle. But what before the breathalyzer was out there, before it was widespread in the 70s and 80s, people would be intoxicated, and all they had to really go on was the police officer's observations, which are pretty easy to cross-examine and to discredit at trial. So because of that, a lot of people were getting away with DWI, or at least so the state believed. So they came up with this chemical test to prove a blood alcohol content. And then they got the really bright idea saying, wait a minute, you know what? So many people are getting away with DWI. Let's have a per se law, statute, which says it doesn't matter if you were driving perfectly. It doesn't matter if they didn't quite prove your ability to drive was impaired based on the way you were operating the car. If you blow over, it used to be a 0.10 or greater, you're per se intoxicated. So it doesn't matter. You could have been driving perfectly. You blew, nowadays it's a 0.08. Some states it's even less. You blew a 0.08 or higher, you're per se intoxicated. So the chemical the chemical test is not, if you fail to blow the 0.08 or higher, that doesn't mean you were legal to drive. You just weren't per se illegal to drive. So you've already been arrested. Because if you do a chemical test and you blow a 0.07 or less, they just can't charge you under the per se statute. So you still got the one count of DWI. You could still be found guilty of it. Another thing that happens if you don't blow a 0.08 or higher is they cannot promptly suspend your license under the prompt suspension law. If you blow a 0.08 or higher in New York and New Jersey, then they promptly suspend your license. And you get it back in New York after 30 days. While the case is going on, you get conditional privileges. Exactly how it works in New York, I don't know. But that's one benefit of not blowing a 0.07, 0.08 or higher. Now, if you blow lower than a 0.08, it's a pretty weak case, so there's a good chance it's going to get dismissed anyhow. But the thing is if you're out there, some people are selling these little keychain breathalyzers. First of all, they're not accurate. Okay, even the chemical test, the machines that the cop use, the Alka-Seltzer, the toxilizer, whether it's a blood test, urine test, or breath test, believe me, they're not all that accurate. The ones you might have in a keychain to blow into after you had a few drinks, like, oh, I'm only a 0.06, I'm legal to drive. No, you're not legal to drive. That's just evidence of potential intoxication. And they're inaccurate. So there's no such thing. That's the whole point. There's no such thing as a legal limit. Get that through your head. If you're watching this video, no such thing. The blood alcohol content is a per se limit that if you blow over it, even if they can't prove you were intoxicated based on the way you were driving, you're still intoxicated because you blew a 0.08 or higher. So if you blow a 0.07 or lower, that doesn't mean they have to dismiss the charges. The cop made a horrible mistake. No, he didn't make a horrible mistake. it's going to be a much weaker case. You're not going to lose your license. During the pendency of it, it's better to blow .07 than not, than higher, okay? Now, Bruce Springsteen, he blew .02. So now, here's another thing. If the facts were true, that he's sitting on his motorcycle, hanging out, pressing the flesh with some fans, and he blows he blows his he gets arrested and blows a .02. Well, you get arrested now, and by the time you take the chemical test, it's a half hour later. Under New York State law, for a chemical test to be entered into evidence to be valid, the police have to get the sample within 2 hours of the arrest, because otherwise it's inherently unreliable. So now it's a blood alcohol content. It's not a body alcohol content, which means you take if I take a shot of alcohol right now, or even just guzzle a lot of booze right now, it's not in my blood yet. It's not in my bloodstream yet. It's in my stomach. It hasn't absorbed through. It doesn't absorb through your bloodstream. It takes a little bit of while to do that. So the information about Bruce Springsteen is the cop was like sort of on scene or was right there when he did this shot. Then he arrests him within a couple minutes, let's say 10 minutes, 15 minutes of doing this shot, right? So at the time, so if he blew .02, you reverse extrapolate how much alcohol he drank, his weight, his age, his general metabolic rate for his age, and you say, you know what? Even though he blew .02, that was like an hour later. It was impossible to have absorbed into his bloodstream, at the time he was arrested. So in this particular case, because his blood alcohol content level was so low, that BAC actually helped to prove he was not guilty, and that was one of the main reasons why I said this case is going to be dismissed. That was one of the main reasons I said that. I believe that. So just because you blow a point, whatever, a BAC, it doesn't mean that, now it could work. Now it could work the other way too. They could get you while you were shit-faced, plain English, okay? And then about 2 hours later, they ask you for a sample, and you give it to them. By then you could be more sober. That's why they ask you for 2 samples within 20 minutes of each other. At least in New York State, I'm sure they probably do it in other states too. Because if you give your first sample, you blew a .12. And then you give a second one 20 minutes later, and you're .11. If it goes down, then they could tell you were more intoxicated at the time of the arrest, and the opposite is true. That if you blow .08 and then it's .09 20 minutes later, you were less intoxicated at the time of the stop. That's how they can extrapolate. And depending on which way it moves, it's either going to help the defense or the state. Another thing, kind of reason why I thought he was going to be dismissed, is that he was on federal property. So it wasn't a state case. It was a federal case. Now, I've had this with traffic tickets. I represent people who get traffic tickets in West Point, at the military academy. That's federal property. And the first time someone told me that, I said, send me the ticket, because I've never seen a federal ticket. It looks different, but they charge them under state law, Vehicle and Traffic Law 1180 for speeding. And I'm like, well, shouldn't they be charging under a federal statute? No. This is what they do. What the federal government will do when they have, federal property, parks, military installations, what they'll do is they'll have a compact with the state, and what they'll do is they'll say, hey, they probably have some sort of overarching statute that says, federal law says we could do this, and they'll just have a compact with the state saying, hey, anyone gets charged for speeding or whatever, DWI, or any crime, maybe it's like probably a felony is going to be under federal statute, but any misdemeanor or any traffic matter, we're just going to import your substantive law. So Bruce Springsteen was charged under New Jersey state law. but he was in the federal system. And that makes a big difference. And here's why. First off, these federal magistrates, they don't want to do traffic tickets and DWI cases. The federal court has a better thing to do than prosecute people for DWI. They don't care that much unless you really hurt somebody. So they're going to be more lenient than the state authorities. But this is especially so in New Jersey. New Jersey takes DWI extremely seriously. There's a couple things about New Jersey DWI. One, no plea bargaining. You cannot plea bargain a DWI case in New Jersey. So it's either you're going to plead guilty as charged or take your case to trial. Two is if you refuse a chemical test in New Jersey, it's a separate criminal charge. Whereas if you refuse in New York, you're going to have only administrative penalties if you are found to have refused within the meaning of the law with a DMV. You're just going to lose your license for a longer period of time. But if you refuse in New Jersey, it's a separate criminal charge. Now, Bruce Springsteen didn't refuse, so he didn't have that to worry about. But not only can you not do plea bargains in New Jersey, they have a law that says any DWI case has to be done in 60 days. So they push these things through the system. The thing is, if you want to really prep a trial as a lawyer and as a defendant who wants to put the effort and time and money into fighting it, it makes it very difficult because they're on this 60-day time clock. Now, in the federal system, while you are applying New Jersey substantive law in Bruce Springsteen's case, because he was on a federal property when he got pulled over, when he got arrested, they're not applying the New Jersey criminal procedure law. They're applying their own procedure law. They're still applying their federal rules of criminal procedure, the rules for discovery under the federal system. So they're only applying the substantive law if it goes to trial. But they don't got the 60-day time clock. It's much more of a political hot potato in the New Jersey state courts than it is in the magistrate federal court. So, he had more time. He had more ability to, and he had a venue that really didn't, care as much about DWI cases as it would have been in state court. And also, not that he's Bruce Springsteen, the rock star, but he has the resources to get the proper legal help that most people really don't have or don't really want to spend the money, especially if you're in New Jersey and you can't even soften them up to plea bargain it or to get it dismissed. I've done a lot of DWI cases in my day, and I've prepped them. I've done pretrial hearings, and I've never actually done a trial because I always got dismissed pre-trial, or I had a really bad case, but I softened them up to the point where my client was like, let me just jump on this offer now. I got a good offer. They know they had a bad case. They know I got it to a point where it made sense for them to take the deal. So I've never actually done an actual DWI trial, not because I wasn't willing to or I was incompetent, but I was able to soften them up pre-trial so much that either I got dismissed on motion, dismissed during a hearing, got so much evidence suppressed they couldn't move forward, or I still beat them up. I still put the prosecutor in a disadvantaged position to where, if I did the trial, I'm probably going to lose, but it was going to be hard, and maybe my client would have won. You never know what can happen at trial, but my client, so they gave me the offer I wanted. You can't really do that in state court in New Jersey. So, and again, Bruce Springsteen had the resources to hire the right lawyer. And I don't know what lawyer he had, but I'm sure what happened was, they took a look at the totality of this arrest, the fact that he blew a .02, which means he had to have been sober at the time of the arrest. It didn't sound like there were a ton of witnesses there. He was hanging out with a bunch of people who probably were going to be willing to testify on his behalf. Doesn't sound like the U.S. Federal Park Police did any field sobriety test, which is you kind of need that to develop your probable cause, So, they probably reviewed the facts of the case, and they probably had a meeting or something like that, and in a collaborative effort, they realized there really was no case here. And it got dismissed. But it really raised a lot of interesting issues. And the overarching point that I want to bring to people is, if you drink any amount of alcohol and then get pulled over, or God forbid get in an accident, even if you're rear-ended, and they suspect you were drinking, it's not a legal limit. You could have had a drink right before you got in the car, a little nightcap, and something happened, and there's a little bit of alcohol in you, and somehow you get arrested for DWI, and you blow .03 or some very low number. That doesn't mean you should walk. I mean, maybe you really weren't intoxicated, but in and of itself, you blow .07 or less, you're not walking. It's evidence of intoxication to prove their common law observational count of DWI. You're just not going to get charged with 2 counts of DWI. That's the only thing that's going to happen to you. There's no such thing as a legal limit when it comes to blood alcohol content, and it's just advertised that way for some reason. Oh, he's below the legal limit. No, you're not above the per se illegal limit. That's what it is. Anyhow, I think I went on. I made my points. Listen, share, like, and subscribe. A lot of people are starting to subscribe to the channel. Jump on it, subscribe, hit the thumbs up button, share it with your friends, and I'm going to continue to bring you guys more great content. I was just glad I got this piece out, and we'll be seeing you at the next video.